The goal of this training is to help guide you as you perform your duties on the council. We're first going to go over an overview of the Brown Act itself. Then we're going to go over understanding how to apply the Brown Act to your day-to-day duties on the council. This is a 3-step process. The first step is determining who does the Brown Act apply to. The next is determining what qualifies as a meeting. And then the third step in the process is to understand what the Brown Act rules are for meeting requirements. I'll do a brief primer on the Public Records Act and as it applies to your duties on the council. I'll go over the consequences of violating the Brown Act and then some best practices. 2 things I just wanted to mention at the outset of the training is obviously these slides are very detailed and they're intended to be reference material for you to take home. And I think you'll learn best by discussing potential Brown Act scenarios among yourselves, so I reserved about half of the training for you guys to do that. So this slide has 3 sections from the Brown Act. It was enacted in 1953, and it's evolved ever since through a series of court decisions. The first paragraph is the Act's original section, which declared the legislature's intent when it enacted the Act, and that was that all meetings and all deliberations of public agencies be open to the public. The third paragraph in this slide is the section of the Brown Act that has remained unchanged since it was first enacted. And that paragraph is the heart of the Brown Act, and it's the portion of the Act we'll be focusing on during this training. And to highlight that point, I put that paragraph on its own slide. This is the sentence that, the portion of the Act that guides the activities of all governing bodies of local agencies. And that it states, as it states, all meetings of legislative bodies of local agencies shall be open and public except when the Brown Act authorizes otherwise. So it's important to remember during this training that the law related to the Brown Act is often not 100% clear. The phrase, an ounce of prevention is worth 100 pounds of cure, is especially relevant when it comes to the Brown Act. And the trend over the last 75 years is for the courts and the California Attorney General's office. They usually broadly construe the Brown Act in favor of greater public access and narrowly construe the exemptions to the general rules. So in understanding how to apply the Brown Act requires a 3-step analysis based on the portion of the Act that we just discussed. So the first step is to determine if you're part of a legislative body. The second is to determine if you're partaking in a meeting. And if the answer is yes to both of those, then you must know how to follow the Brown Act's meeting rule requirements. So over the rest of the training, I'm going to go over those 3 steps. So step 1, to determine if you're part of a legislative body requires knowing how the Brown Act defines legislative bodies of local public agencies. The Brown Act defines legislative bodies as the agency's governing body and all boards, commissions, task forces, executive search committees, and other appointed bodies created by formal action of the governing body, whether permanent or temporary, decision-making or advisory, including planning commissions, volunteer groups, and other subsidiary committees, boards, and bodies. Also included in the definition are standing committees of legislative bodies, regardless of the number of members, which have either continuing subject matter jurisdiction or a meeting schedule that's fixed by charter, ordinance, resolution, or formal action of the body. And even newly elected members of these bodies who have not yet been sworn into office are covered. And lastly, it might not come up for this council, but you should be aware that certain governing bodies of private organizations can also be subject to the Brown Act. The factors that bring them under the Brown Act is if they are either created by the legislative body in order to exercise authority that may be delegated by that body, or if the private organization receives agency funding and its governing board includes a member of the body with full voting rights. And the lesson from this is that the Brown Act defines the legislative body extremely broadly and includes just about every type of decision-making body of a local agency. So what is not a legislative body for purposes of the Brown Act? The exceptions are narrow and consist of the following types of committees and groups. First, a legislative body can create an ad hoc advisory committee, and it won't be subject to the Brown Act requirements. But this requires that the ad hoc committee is comprised solely of members of the legislative body, that are less than a quorum of the body, that serve a limited purpose, that's short-lived, and usually no more than 6 months is acceptable for an advisory ad hoc committee. Examples of ad hoc committees include advisory committees created to interview candidates or a vacant position or to meet with representatives of other entities. Second, the other groups that can be exempt from Brown Act requirements are groups that are advisory to single decision maker or appointed solely by staff. And since the Brown Act applies to committees created by formal action of a legislative body, in order to meet the second exemption, any groups created to advise a single decision maker could not be created by the body itself, or that would bring even that group under the Brown Act. For example, a committee advising a CEO would not be covered by the Brown Act unless the committee was created by formal action of the legislative body.
So if I may interrupt for just a moment, I wasted some time at our first meeting. I was looking for an opportunity for all of us to be less formal so that we could communicate more openly. And this second provision makes it clear, because we do not report to the CEO as a committee, we report to the policy board. As Mr. Osmer pointed out, we are under the provisions of the Brown Act. So I'm sorry that I took us down that path last month. I was hoping we could be less formal in all of our requirements, but they do apply to us. Thank you. I'm sorry to interrupt.
So that's the first question on your practice scenarios. So does this council have less restrictions because it's only an advisory body? And as you mentioned, you already answered the question.
Oh, good.
For that.
Great segue.
So my intention with all these practice scenarios is that you would spend time thinking about them amongst yourselves, coming up with answers, and I'll tell you what the answers would be based on the applicable case law and rules. And we can go over them as quickly as you want, but I think it's good to practice because it's really not,
Please go
completely
ahead,
clear.
as you intended, ask the questions.
Okay. Does this council have less restrictions because it's only an advisory body, and why or why not? I'll leave it up to you, and I'll tell you the answer.
I'm calling you.
No,
Why?
because we report to the policy board. We're under the full provisions of the Brown Act.
Because you were created by the policy board.
Ah.
You're not an ad hoc advisory committee. You're long-term. And there's no exceptions under the Brown Act for an advisory body in that situation.
Okay.
Okay, second question. If this council creates a long-term committee on local public interest in biofuels program, is it subject to the Brown Act?
Yes,
Why?
because it's longer than 6 months.
Yep. Exactly. That would be called it's a committee of a citizen advisory council, and it's subject to the Brown Act. A member of your council informally establishes an advisory committee of 6 residents to advise her on issues as they arise. Does the Brown Act apply to that advisory committee?
No,
Why?
because the individual did it, not the board.
Exactly.
Good. We're 3 for 3 here
That's
so
good.
far.
You guys are doing well. Okay, during a meeting of your council, you request that the CEO forms an advisory committee of residents to develop recommendations for a new local renewable energy program. The CEO forms the committee and appoints its members. The advisory committee is instructed to direct its recommendations to the CEO. Does the Brown Act apply to this committee?
I think it does because the CAC requested it, right?
Yeah, the answer is possibly and most likely yes, and the best practice is.
We're reporting to the CEO.
Yeah, even if it's a reporting to the CEO, because it was created under the direction of the council, that would most likely be considered to be formal action of the legislative body, creating the committee and bring it under the Brown Act. So the lesson from step 1 is to err on the side of caution, and the prudent presumption is that an advisory committee or task force is subject to the Brown Act, and even if one is not, you might want to treat it as a Brown Act committee just to reduce the possibility of misunderstanding and controversy.
So I'm not sure I understand the picture associated with this slide.
I was going to ask the same question.
Is good eggs or bad eggs?
They're happy eggs, brown eggs, sharing a bottle of champagne because they're very happy to be under the Brown Act. As you should all be.
And they're brown eggs. Yes, I see. Okay.
Please tell me when you created that picture.
So the second step in analyzing a Brown Act scenario is, if you find that you are part of a legislative body, is to determine whether you're involved in a meeting. And this analysis depends on understanding what qualifies as a meeting under the Brown Act. So as you can see from the slide, a meeting under the Brown Act is defined as any congregation of a majority of the members of a legislative body at the same time and location to hear, discuss, deliberate, or take action on any matter within the subject matter jurisdiction of the legislative body or the agency. Thus, anytime these elements are met by the legislative body members, then it's considered a meeting of the legislative body, and the Brown Act must be followed. This means the public must have the opportunity to participate and observe all the other Brown Act meeting requirements that must be followed, which we'll go over in step 3. For now, it's important to remember that to understand what qualifies as a meeting, and just remember that it's a very broad definition. So the next few slides are the Brown Act listed exceptions to what qualifies as a meeting of the legislative body. These exceptions are construed very narrowly, and they are also not always straightforward to apply in practice. The first exception is for individual contacts. The Brown Act does recognize that each member of a legislative body has a right to confer with constituents, advocates, consultants, news reporters, staff, and or a colleague. It doesn't limit a legislative body member from acting on his or her own. However, a series of these contacts cannot be used to do in stages what's not permitted in a single instance. So there's no series of communications that would result in a meeting. And that's known as the serial meeting prohibition. We'll discuss that prohibition more in depth later, because it's one of the most frequently asked about Brown Act issues and the most common Brown Act violations.
So the key question that I wanted to make sure I understood, and that all the members did as well, it's okay then for members to send me emails or call me to discuss an item they would like to see added to the agenda, or a topic they want to make sure we discuss sometime in future meetings. Anything like this, as long as it doesn't turn into a serial meeting, is okay then, correct?
It's okay. There's always the danger it's going to come into a serial meeting. But yes, individual contacts one-on-one is okay.
Because this is one of the things I was after, is making sure all the members realize they can contact me or the vice chair to
The problem is can I ask you to hold off on that until
Okay.
we get to the serial meeting prohibition, because we're going to go over that in depth. I think it might answer that question.
Okay.
The second listed Brown Act exception to the meeting requirement provides that attendance by majority of the legislative body members at conferences, seminars, and other local agency meetings, community meetings, workshops, and similar gatherings is okay if the event is open and publicized to the public, conversation is limited to issues of general interest, and a majority of the members do not discuss amongst themselves business of specific nature that is within the subject matter jurisdiction of the agency, except as part of a scheduled program. The third exception is that attendance by the members at meetings of standing committees is permitted, so long as non-committee members only observe and do not participate in the meeting. The fourth exception states the majority of the legislative body can attend the same purely social or ceremonial events, such as a football game, party, wedding, funeral, etc., so long as they do not discuss business amongst themselves of a specific nature within the subject matter jurisdiction of the agency. The test is not whether or not a majority attends the function, but whether or not business of a nature within the agency's jurisdiction is discussed. However, as we'll see kind of later in the discussion scenarios, it might be good to avoid those types of situations, just to avoid the appearance of impropriety, even when the Brown Act violation isn't occurring. The fifth exception is that certain staff briefings of the body is okay, even when sent to a majority of the members, so long as the briefing is solely informational or advisory and sent unilaterally. And here, there needs to be care that no one sends reply all on an email, because then that does create a meeting. And it should be noted that any memo that is sent to the body in that manner could become a public record, subject to the restrictions on that, exceptions on that, and that staff, when briefing the body, needs to exercise care not to disclose the other members' views and positions. So next, I'm going to go over some common Brown Act violations to be aware of related to improper meetings. Collective briefings, none of the exceptions permits a majority of the body to meet together with staff in advance of a meeting for a collective briefing. Any such briefings that involve the majority of the body in the same place and time must be open to the public and satisfy the Brown Act meeting and notice and agenda requirements. Except for certain non-substantive purposes such as scheduling, a conference call including a majority of the members is an unlawful meeting. The Brown Act does allow the use of teleconferencing to hold meetings, however, only if the public can be present at the teleconference locations and subject to very specific teleconference requirements. Those requirements include that at least a quorum must participate within the agency's jurisdiction. All teleconference locations must be made available to the public. Agendas must be posted at each teleconference location, even if it's at a hotel room or residence, and all votes must be made by roll call. Third, as we discussed earlier, the broad definition of meeting means that even reply all to an email can create an unlawful meeting. And last, informal gatherings at which local agency business is discussed or transacted violate the law if they are not conducted in conformance with the Brown Act. For example, a luncheon gathering in a crowded dining room would violate the Brown Act if any business was discussed. And last, the most common Brown Act violation is related to serial meetings. The Brown Act states that a majority of the members of a body shall not, outside a meeting, use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of business that is within the subject matter of the body. That means that it's prohibited to have direct or indirect communication employed by the majority to develop collective concurrence as to action to be taken. And this can occur in two different ways. There's the daisy chain serial meeting, where member A contacts member B contacts member C contacts member D, and so on until a quorum is discussed, deliberated, or taken action on an item within the subject matter jurisdiction of the agency. Any device that's used to achieve the same, such as an email daisy chain, is also an improper serial meeting. The second is the hub and spoke serial meeting. That can happen in two ways. First, member A acts as the hub and sequentially contacts member B, C, D, and so on, which are the spokes, until a quorum has been contacted. The second is where a staff member acts as the hub and functions as an intermediary for the legislative body or one of its members and communicates with the majority of the members, the spokes, for one-on-one discussion, deliberation, or decision on a proposed action. This can occur if the CEO acts as the hub and briefs the majority of the members, the spokes, prior to formal meeting, and in the process, information about the members' views are revealed. So now is your time for more practice scenarios. So consider, Councilmember Groot receives a phone call from a wind company lobbyist who says, "Say, what is your opinion on whether the agency should stop signing contracts for utility solar and should instead only buy in-state wind energy?" "Well, I don't know," replied Councilmember Groot. "That's kind of a complex issue. Have you talked to any other council members about their opinions?" "Well, I've spoken to 4 councils in Santa Cruz, 2 in San Benito, and they're all leaning towards supporting rooftop solar. With you, it would be sure recommendation by the council to the board that the agency should stop pursuing utility solar," replies the lobbyist. Moments later, the phone rings. "Hey, I've been hearing some rumbles that the council is going to be recommending the agency no longer pursue contracts for utility solar," says the newspaper reporter. "I'm counting noses. What are you going to recommend?" So what do you think? Is this an improper meeting?
Yes.
And why?
Well, this is the hub and spoke situation where we've got the hub being the lobbyist, right?
Is that what everybody thinks?
Well, but they didn't get a majority, right? If we have an 11-person board, you need to have 6 people have that conversation.
So you have 4 from
7.
Santa Cruz, 2 from San Benito, and the 1 answering the
majority.
call, so you have
Not
6.
as
Yeah,
large.
it sounds like hub and spoke, I agree.
Yeah.
So neither the lobbyist nor the reporter is actually on the body, but they're facilitating a violation.
Right.
And the council member may have violated the act by hearing the positions at other council. This isn't a real clear-cut yes or no question. By coaxing the lobbyist to reveal the other council member's position, at that point, they're probably violating the act. The prudent course when you're having that sort of situation come up is to avoid leading conversations and to caution the people you're talking to not give you the opinions of the other people in the body.
The other thing that's troubling here is there's a financial interest on the part of the person making the phone call, which is a red flag to any of us.
Yeah. Okay. So the next question. Every Wednesday at 5 o'clock, the council meets at Gale's Fish Shack for an hour of talk and fellowship. They sit at the corner window, fronting the wharf to show they have nothing to hide. Whenever she can, the editor of the local newspaper comes over to join them. What do you think about this?
It's a potential meeting.
It's not advisable, yeah.
Yeah, technically they're not doing anything wrong, but the appearance. But if we have a local news porters sitting right there watching what we're doing, is that?
It's gonna be headline news the next morning.
It's not noticed. This is a CAC meeting that's not noticed.
So this could be come under the social exception, and if everybody scrupulously avoided talking about agency business, you according to the not be violating the Brown Act, but that might be really hard to do. And as Natalie mentioned, it's more the appearance. The public might have trouble believing that you guys can get together and not talk about agency business, so you might not want to do it for that. Okay. Next question. The local
A glass of wine, though, in each in our hands, we'd be okay then, right?
could be even harder to stick to the rules. Okay. So the local Chamber of Commerce sponsors an open and public meeting about energy issues in San Benito County. 6 of the 11 council members attend to participate. All of the members are asked their views of a controversial energy contract scheduled for consideration at a council meeting to occur the following month. May the 6 members answer the questions.
So you know she's going to ask you why.
I'm going to say yes.
I'm gonna say no because there's a majority there.
It also could be a serial meeting. You're essentially providing your view in a public setting that's not a noticed meeting.
Also, the subject of the meeting falls under the purview of this body, so that's definitely a no-no.
So this is a really good one to think about how hard it is to answer this. The majority of the body can attend this meeting and even respond to questions as part of the normal program under that's the attending the community meeting exception to the Brown Act. But if the conversation turns to majority discussing amongst themselves agency business outside of the scheduled program, then a Brown Act violation will have occurred. So the best practice is to avoid this type of situations because there's such a fine line between what's permitted and what's not. But there's really, it's a tricky line to walk. The next
So
question.
everybody could get up and give their own opinion as long as I don't talk to.
As part of the
someone
program,
about it.
as
Well,
part of the
wait.
scheduled
Then
program.
we would have the opinion on how 6 CAC members were planning to vote in a meeting that was coming up.
Could be a serial meeting.
Yes.
If it's part of a normal scheduled program and you're not talking amongst yourselves, there is an exception to the Brown Act, but then do you come into the serial meeting?
And it's an
I would
appearance
recommend against it.
too.
I mean, it's one of those things.
Another notion that I'd like to bring up from the benefit of my members at the Energy Commission, we used to always joke, never speak on behalf of another commissioner. You never want to indicate you know or understand their mind on an issue, certainly in any public setting. It's not a Brown Act violation, it's just good policy.
Okay, the next one, the entire council intends to testify against a bill before the Senate Local Government Committee in Sacramento. Must this activity be noticed as a meeting of the body?
Say yes.
I mean, this is very similar to the last one, as long as we don't step aside and talk to others about what our opinions are.
Yep.
If we just give our own personal opinion and then close our mouths and walk away, it's part of the
It is.
program.
It is, it's exactly. The answer is no, because the members are attending and participating in an open meeting of another government body which the public may attend. That's what case law has determined is okay. So then the next scenario, if the members then proceed upstairs to their local assembly member to discuss issues of local interest, must this session be noticed as a meeting and be open to the public?
If they're talking about scope of this committee, yes.
Because the entire body may not meet behind closed doors except for a proper closed session. And the same answer would apply if you went into a private lunch or dinner with an assembly member. It's not allowed.
These are very good.
Okay. So one more set of them. The council wants to hold a team building session to improve relations among its members. May such a session be conducted behind closed doors?
Yes.
You
If
know, she's-
scope isn't talked about.
This is no. The meeting must be open to the public. The council's relations are considered to be a matter of public business. This is not considered to be social. And the only way it could be held is if it was a closed meeting, and there's no exceptions which would apply for that.
Can I ask a question?
Yeah.
What is a closed meeting? What are the requirements?
I'll get into that later, but that's unlikely to come up for this council. The instances in which you can go into a closed session are extremely limited. I'll go over those, but definitely not applying to team building. Next question. The agency's website includes a chat room where its employees and officials participate anonymously and often discuss issues of local agency business. Members of the council participate regularly. Does this scenario present a potential for a violation of the Brown Act?
Yes.
Oh, yeah.
That's correct. It's a technological device that may serve to allow the majority to discuss, deliberate, or take action on matters of agency business. The chair of the council contacts 6 other members on the 11-member council relative to scheduling a meeting. Is this an illegal serial meeting?
I don't think so.
Yes, because what if I was only contacting those 6 I wanted to attend?
Right.
That's not even envisioned in that. No, so there is an exception. So you're allowed to contact people merely for scheduling purposes. However, you should avoid, there shouldn't be any discussion amongst the merits
So,
during that scheduling. But if you were, that would be a different issue if you were only contacting people you wanted to attend. That's an interesting one.
and it's a majority, so I think that would be a violation.
But I mean, what if
just-
the other 5 people
It's-
can attend and you're just checking with the other 6?
I'm just
and
going
so
on
not
what she
sure?
presented here. It
Yeah,
doesn't say that.
it's not considered to be a violation, but
Okay.
that's also, it's not considered that would actually even happen. That's an
If it's
interesting
actually a s-
scenario.
Actually, a special meeting, there are provisions for noticing and all of that as well, so
So
that's just calling people to see if
you're
they're
just
showing-
scheduling,
Yeah.
yeah. There-
Okay,
I-
good.
Yeah.
Good. So
As the
does that
chair, you are
answer-
allowed to schedule a special meeting, and the legislative body is allowed to schedule a special meeting too, so.
But wouldn't I normally,
you
under
are-
those circumstances, send an email to all members at the same time saying we're trying to?
It's a good point,
It
yeah. That's an interesting one. Definitely improper. I don't know if it'd be a Brown Act violation.
schedule a
That would
meeting.
be,
Hang on, say again?
well, I don't know if it'd be a Brown Act violation.
Okay, so let's ignore
'Cause
that.
you're just
I want to make
scheduling.
sure we
You're
do
not
it the
talking
right
about
way.
agency business. If you're just really trying to find a time, and you're not, there's no agency business discussed at all, that's not a Brown Act violation. But that's definitely not doing a very good job as the chair.
Right. I think the
Chair.
way we'd normally do it, you're saying I could send an email to all the members of the committee if we're trying to schedule a meeting.
You could, preference is to go through Bren and
Yes.
help her do that.
Yes,
And
of
that
cour-
just avoids the whole
Yeah. I
possibility.
would love
You'll
to juggle
notice-
these 11 schedules. I'll
Yeah.
certainly leave that to Bren.
And you'll notice on every email from all of us, it's don't reply all in big, bold letters.
Yes, we
for this
have
reason.
noticed that.
Yeah.
So, Mr. Stedman, you said something.
No, I was just gonna say Bren would handle that. You probably
Yeah.
shouldn't be doing that.
Okay, the last one on this page. The council establishes a standing committee of 5 of its 11 members, which meets monthly. A non-committee member of the council wants to attend these meetings and participate. May she?
No.
No, she can attend, but she can't participate.
Exactly. That's correct.
Very good.
Good student. Okay. So step 3. If you have a legislative body and a meeting, there are only 4 types of ways that those meetings can be held. The 4 types of meetings that can be held under the Brown Act are regular meetings, special meetings, emergency meetings, and adjourned meetings. All of these types of meetings require that the meeting agenda adequately describe the items to be considered, effective notice to the public be provided, and they have special rules on the based on the meeting type. For regular meetings, they must be set by formal action of the legislative body. The agenda must be posted 72 hours in advance continuously in a location freely accessible to the public. The public must be able to speak on any matter on the agenda pre-deliberation and on any non-agenda item within the subject matter jurisdiction of the agency. Special meetings are subject to similar requirements as regular meetings, except that they may be called on 24-hour advance notice by the chair or majority of the legislative body. Emergency meetings can only occur in specific instances in which 2 grounds for emergency exist. They must be severe impairment to the public health and safety, natural disaster, mass destruction. It has to be something really emergency.
I would imagine those really don't apply to an advisory
Yeah.
council.
And an adjourned meeting is one of these types of meetings that it's adjourned to a subsequent date. The Brown Act contains extensive requirements about the content and posting of meeting agendas, and this is because if nobody knows about the meeting or has advance notice about what's going to be discussed, then the public participation cannot occur. As such, every legislative body meeting, advisory commissions, standing committees must be preceded by a posted agenda that advises the public of the matters to be transacted. And since the agenda does provide the notice that's required for the meeting to be effective, it requires actually quite careful planning when it's put together. And subject to very limited exceptions, the Brown Act prohibits any action or discussion on an item not included on that posted agenda. The exceptions for discussing a non-agenda item during a meeting are very narrow and require specific findings be made before they're discussed. If those specific findings are not made or they're invalid, then the meeting itself or the actions taken can be invalidated by a court. The emergency exception for adding a non-agenda item requires a majority vote that a true emergency situation has occurred or exists. The urgency exception for adding a non-agenda item requires a supermajority vote of the body, and that the circumstance arose after the agenda posted and the staff didn't know about the circumstance before posting the agenda. To use this exception requires a real degree of urgency. For instance, if a staff just forgot to put it on the agenda, that would definitely not qualify. It also requires a 2-step process. First, that we make a determination there is a need to take immediate action, and that immediate action arose after posting the agenda, and then that matter gets put on the agenda and it gets discussed and acted on as a normal agenda item.
So, Mr. Habashi, do we get the benefit of counsel at each of our meetings from now on? As the policy board does, as the operations board does?
If you do request it, by all means, sure.
Well, we're subject to the same provisions of the Brown Act, and in those 2 other boards, you've got elected officials for the most part. I don't know that we have very many of those here. We want to make sure we follow this act, so we may need some help. I'm looking really more to my members here.
I just remembered that we're in the process of hiring a general counsel, so yeah, of course. It's a salaried employee, it will be, and we will ask that general counsel to attend every board meeting and every council meeting.
I mean, my sense is Ms. Lair knows these laws pretty well and could advise us, but she's not an attorney, and none of us want to go to jail.
Including
Got that, yes.
Okay.
Okay, in the event that a matter is raised during the public comment period for non-agenda items, the ways in which the council can respond are any of the following: brief responses to comments and questions, clarifications in reference to staff, brief announcements and reports and activities, or requests for future reports or placement of those items on future agendas. A number of the Brown Act provisions cover protections of the public's right to attend, observe, and participate in the meetings of legislative bodies. The public cannot be required to register their name or provide any other information as a condition precedent to attending or speaking at a meeting. There can be no action by secret ballot, whether preliminary or final. All actions and the vote of each member must be disclosed to the public at the time it's taken. Ejection of any persons is justified only when the audience members actually disrupt the proceedings. And except for privileged documents, all writings distributed to a majority of the body in connection with the agenda item must also be available to the public. Also, the public and press are allowed to use audio or videotape recorders or still or motion picture cameras at a meeting to record the proceeding. A few other miscellaneous Brown Act requirements are listed here. The meetings must occur in the location where the agency exercises jurisdiction. There's limited exceptions to this to comply with court order, inspect real property, participate in multi-agency meetings, and meet with other elected officials when a local meeting is impractical. And as I mentioned earlier, closed sessions are permitted in very limited circumstances under the Brown Act. It's unlikely to come up for this council, but just so you are aware of them. Some of the closed session exceptions include real estate negotiations in certain instances, consideration of existing litigation or anticipated exposure to litigation, public employment consideration or reviews, and labor negotiations.
So I suspect this council doesn't want to see any of those items on our agenda.
They're not going to come up. But you might see them come up on the policy board, and I mean, it's good to know what's happening. So now we'll do a last set of practice scenarios. So the first question is, may a regular meeting of the council go forward if its agenda was not posted in a location freely accessible to the public from 2 a.m. to 3 a.m. during part of the 72-hour notice period preceding the meeting?
No. No, because it must be posted for 3 days continuously.
That's correct. And there's no exception to that requirement. The Brown Act calls for substantial compliance, and 1 hour wouldn't be considered substantial. Question 2, the agenda for a regular meeting contains the following items of business. The first one is consideration of a report regarding solar programs in San Benito County. The second is consideration of a contract with ABC Consulting. Are these agenda descriptions adequate?
No,
The
this,
consulting would have to say
for
what
what?
it deals with,
Yeah,
and same with the solar programs.
Can you speak up a little?
Oh, I'm sorry, yeah, I forgot. So the taking the last one first, the AB Consulting would have to identify what the contract is about, and I would say that would require more specificity on solar programs, which solar programs those are. That's pretty generic.
I would agree with that. So the question is whether agenda item provides the public sufficient notice in advance as to what the body is considering, so it knows that it could, come and participate. And I agree with that comment. The first one, barely adequate, if adequate. It doesn't really provide the reader any idea what the report is about and what's being recommended. And the second's definitely not adequate. So the last one on this slide, a council member is on vacation and wants to participate in a regular meeting of the council and vote by a cellular phone from her car while driving from Monterey to San Francisco. Can she do so?
No.
I think so.
The location has to be posted and open to the public.
Right.
That's correct. Not allowed.
Wow.
In that scenario, though, I have a question. So if you are in, I don't know, say you're at a conference in San Francisco that weekend, could I participate through teleconference and be like, I'm at this conference in San Francisco. You may come and listen to me speak on this microphone. And
Possibly.
That's okay?
Possibly. You'd have to work with Bren closely and make sure the agenda was posted wherever you are and the public can come. And there's a kind of extensive requirements to make
Okay.
sure it's proper.
So
But it's
people would have to
possible.
be able to be in the room with me.
Yeah.
Okay.
Yeah.
Good to know.
Okay. So I think this is the last one. Does the following meeting violate the Brown Act? I think there's a few more, sorry. So, Chair Byron, I would like staff to respond to resident Scott's complaints during public comment about the proposed purchase of power from a hydroelectric plant in Washington. Are there problems with this project? CO Hibashi. The operations director has a 45-minute PowerPoint presentation that he can give you on the status of that contract, and we'll give it right now. Member Levon, take all the time you need. We need to get to the bottom of this. Our residents are unhappy.
So I suppose we should answer this.
Yes, right?
Violation.
Yeah, it's not agendized.
It's not, yeah. It just pops up all of a sudden, and that's a lot of time to take out of the agenda.
That's right. So when Byron in that scenario asked Hibashi to respond, that was appropriate. But then Mr. Hibashi should have given a brief response, and then it should have been directed for a future agenda item. After that, it was going to embroil the whole council in a Brown Act violation.
So all three of us made mistakes in this one here.
Also, it's very unlikely that I'm gonna have a 45 minutes presentation, whether the item is noticed or not.
And although not part of the Brown Act, I included a brief summary of the Public Records Act as it relates to the council's activities. In addition to the right to observe and participate in the meetings of their legislative bodies, the public has a right to request public records from any government agency under the Public Records Act. These materials include any writing that was prepared, owned, used, or retained by a public agency. Communications subject to disclosure under the Public Records Act include all writings with content relating to the conduct of the public's business, prepared by or owned, used, or retained by any state or local agency. It's important to remember that a writing as defined under the Public Records Act includes any form of communication on electronic devices, including emails, texts, and voicemails, and it can even extend onto personal emails and personal devices. And although there are some exceptions to a public agency's duty to disclose records, the safest practice is assume that virtually all materials involved in one's service on a governing body are public records subject to disclosure.
So, quick question. Obviously, all emails, when you press the button send, that becomes a public document if it relates to business that this committee's doing. What about things that are put on my calendar that are meetings for a public meeting? Does my entire calendar then become a public record that can be
You get to black out the non-agencies. If it's your personal calendar,
okay.
yeah, it gets pretty nuanced
I know.
and detailed.
And it's
But-
going to
but
get
it-
more
but it does,
complicated
yeah.
with more electronic
Mhm.
devices.
Absolutely.
Okay, thank you.
Finally, it's important to know what the consequences are if any of these laws are violated. And those consequences include that any decision made in violation of the open meeting laws can be invalidated. A member of the body who acts with improper intent is punishable by criminal sanctions of up to 6 months in jail or a $1,000 fine. This is just a very unusual situation, and it's a pretty steep bar, but it's important to know about. The intent part requires that the member intend to deprive the public of information to which the member knows or has reason to know the public is entitled. The other consequence is the likelihood that the agency will have to pay attorney's fees to defend the challenges, as well as pay attorney's fees for those who successfully sue the agency. And the most likely one is intense adverse media attention, and the publicity surrounding alleged Brown Act violations can result in a loss of confidence in the body and the agency itself.
So are these criminal proceedings?
There is a criminal possibility. There's civil and criminal. Both.
So is it brought, are these brought under the Brown Act at the state level or the county level, do you know?
The AG, the district attorney.
Okay.
Yeah. As far as enforcement, the most commonly used enforcement provisions are those that authorize the civil suits to invalidate specified actions taken in violation of the Brown Act or stop or prevent future violations. And the legal standard for review of an alleged violation is whether substantial compliance with the Brown Act occurred. In summary, it's important to remember that the Brown Act is incredibly broad. It covers virtually every type of local legislative body, elected or appointed, decision-making or advisory, and even newly elected members before they take office. Meetings subject to the Act are not limited to face-to-face gatherings, but include any communication, medium, or device through which a majority of a body discusses, deliberates, or takes action on an item of business of the agency. And all of this council members should assist one another in observing the act and rely on the expertise of your board clerk, myself, and the future general counsel, and all staff to guide them. And in this situation, you guys are really fortunate to have Bren. She was a board clerk for 15 years for the city of Santa Cruz. She was actually in charge of the department. So I hope you'll lean on her experience in running, these meetings. You're incredibly good hands with her.
Excellent. So I don't mean to incur additional costs for by requesting counsel at these meetings. I'm perfectly comfortable
one of the
relying.
best board clerks
I'm perfectly comfortable
possible.
relying upon Ms. Lair, and I didn't mean to imply otherwise. I just want to make sure we stay out of trouble. That's all.
And then as far as closing best practices, it's important, it's good to consider the Brown Act as a floor and not a ceiling, and make decisions, that go beyond what the minimum requirements of the law are, just to help instill public confidence. And these practices will protect the agency as well as all of its leaders. And then I also put my contact information here. Please feel free to contact me anytime.
Thank you. This is an excellent presentation. I know I learned a great deal, but I'd still like an answer to a basic question that I'm interested in. I want members to be able to communicate with me individually if they wish, to send an email. Can I send an email to all of them saying, I encourage you all to go to the CAC meeting that'll be in Pacific Grove next month because I think it's a really valuable opportunity. Are these in violation of the Brown Act?
The danger is having, if you're discussing agency business, there's a danger there.
Ms. Lair, what do you think?
I don't want to go to jail.
And it's,
I would just suggest don't reply to all. Just you can put that out there. They don't have to reply, but maybe a one-on-one is fine or a phone call.
Okay, so I want to make sure that members understand. This is the part that I'm concerned about. I want you to feel free to be able to call me and give me feedback and/or any suggestions that you might have. I think we should be very careful about making sure we understand the provisions of the Brown Act. But I know that I've communicated directly via email and by telephone with the vice chair. We're trying to conduct the business of this committee, and I'm concerned that that's a potential violation of the Brown Act.
it is. It is a potential violation.
Mr. Chairman, in the past month, I have sent to this council as well as the board of directors on the policy board of directors as well as the operations board of director, certain information that I thought when it came out need to be shared with all of you.
It's fantastic. I
you
meant
did
to compliment you on that. It's
And,
very helpful.
and at the end, I said, please do not reply. This is information that I thought it was important that you all know about it. To the extent that you have, for example, a bit of information, there's this meeting that CalCCA is going to be meeting, and I got to know about it. I recommend that you all show up. Please don't reply, or definitely don't reply to all. I don't think that's going to be an issue. And I think what I'm hearing Angela is concerned about is that you encourage the board or the council to call you whenever they feel like it and discuss an issue, and the next thing you know, 4, 5, 6 of them are calling you to say, we would like to talk about this issue because of, and that becomes a Brown Act violation.
Okay.
It's a dance.
So I do want to make sure we understand this, and I think my takeaway from this is that when I want to communicate something to the entire members, I will send it to Ms. Lair and ask her to put it out there.
That's like that's a safe way to do it. I've seen the emails and the way that Tom's been doing it has been proper. It's a unilateral, informational, advisory communication, and there's a don't reply at all.
Right.
And so.
Okay. Does anyone else have any comments or questions? Because I think we're going to try and move on here.
So are we able to mimic that then? If I wanted to send something out to the entire council, I could do the same thing, but I just have to, at the bottom of it, say, please do not reply all. I am not a hub.
You just have, yeah, I mean, you're sharing your views. You just have to be careful of the serial meeting. I would say that I mean, if there's one thing you walk away with the training is it's not 100% clear, and just be aware of the rules and avoid a serial meeting and avoid violating the Brown Act. That's,
So what about,
no, I don't think it, you're going to talk to one attorney that thinks one thing and another attorney that thinks another thing, and then, you have to do the best you possibly can to hold all of your agency business and all of the meetings in public, because that's now you're part of a legislative body of a public agency, and that's, the public needs to be a part of the thinking and the deliberations, and I mean, that's the whole purpose of the Brown Act.
yes, we got that. So now, but we're talking about specifics now.
Yeah.
We have report out meetings that we're going to do to the operations and policy boards. There may be other opportunities that come up when we're going to be asked to speak. And what I foresee is that I may send an email or phone one of my other members and say, we can't do this report out. Would you be willing to do it? That should be perfectly acceptable, right?
Yeah, a lot, and it's different depending on which agency you go to, but a lot of, I would say, like, what's common is a lot of times when one of the body wants to send something to everybody, they give it to staff, and the staff does a unilateral communication.
Yeah,
That's
okay.
just a very clear, kind of like protects everybody kind of way to handle it.
All
So
right.
that's what I would recommend as a best practice.
Okay. So any other comments? I'm sorry to bring these up, but I wanted to make sure I was clear on them. And I hope you understand that I do want your input occasionally. As long as you're not in violation of the Brown Act, please give it to me, okay? And or the vice chair. In fact, why don't you send it to her? That way I know I won't be in violation of the Brown Act.
Why don't you send it to Brent? Brent will send it to me.
Okay, so any other comments on this? Council, I'd like to thank you very much. Very good presentation.
Agreed. Thank you.